In the Brian Kohberger, Idaho 4 case, just so many questions have been swirling around from the very beginning. The 8-hour delay, and now the questions about Dylan Mortensen and Bethany Funke. And not only that, talk in recent hearings about blood on a handrail and body fluids on a glove outside. Okay, that's all passed, but now that we know about all this stuff, how will that affect the trial going forward?
Were both surviving victims actually interviewed? I'm Lainey Law.
And I'm attorney Andrew Myers.
Why are we talking about Dylan Mortensen and Bethany Funke today?
Well, we've been talking about them, and a lot of people have been talking about them ever since November 13th of 2022. But in my view, there are some new questions about them in the hearings that were held in late January, of course. It was brought up that Dylan Mortensen may not have been so sure of herself, during interviews that were done by her, and that the Moscow police, in their haste to put together this probable cause affidavit, which we find out was now a community effort or a collaborative effort, so that no one witness can be put on the stand. In my view, collaboration is great. We as attorneys are invited to collaborate. I was in a adoption court. I don't do that sort of thing, but I was in an adoption court one day, and the judge was magnanimous in telling all of the attorneys, and it takes a lot of attorneys sometimes in those cases, and he was very gracious to the attorneys and gave them act for collaborating. We're all encouraged to collaborate. But when you do an exhibit to a probable cause affidavit, and it turns out that multiple, half a dozen, we don't even know how many different law enforcement people were involved in putting it all together in these committee meetings and phone calls and conferences, that no one officer can be put on the stand. If they put Mr. Mowry or if they put Mr. Payne on the stand, they can say, "Oh, I don't remember. Oh, that must have been someone else." So the whole Exhibit A, which William Thompson has said is no longer relevant, they actually relied on that to get probable cause for all these warrants, to get all the material, the Google and the Apple and all the rest. And also to arrest Mr. Kohberger, with the flashbangs in the middle of the night. That probable cause affidavit and Exhibit A to it were relied upon to do all of that. And probable cause is a pretty serious concept. And so now there's all this wiggle room. And now, as it turns out, to answer your question directly, it turns out that Dylan Mortensen might not have been so sure of herself. She might, when they use her to say, well, he was athletic, but he was skinny and he had bushy eyebrows. Somebody, when we were preparing our episodes, one time said, "Andrew, you have bushy eyebrows." Anyhow, so she wasn't so sure of herself. And Bethany Funke was used in the exhibit, but not really. She was only used to establish the timeline. What time did people get home? What time did they allegedly go to bed? But Bethany's actual observations are nowhere to be seen. And to me, that's a big question. What did she see? Don't tell me she was sleeping like the police said initially, because no, the girls were in fact texting back and forth. Ashley Hush Jennings had said that in her arguments late in January of 2025. So that to me is a real problem, that this PCA was done by a committee. It was done by collaboration. Yeah, it's great for us to do stuff by collaboration. But when it comes to, depriving someone of their freedom and getting all of this material from all kinds of places, I forget how many warrants were sought. One time we did an episode on it, and I think there were, upwards of 20 of them. For a probable cause affidavit to be based on all of that, it's just, I don't know. It just, to me, that seemed really standing out. It really stood out to me. So I have an idea that it's not going to bode well for the prosecution when they get to their trial. Let's take a look at a document before these hearings that might shed some light on what I'm talking about. This is a notice of filing a list of stipulated exhibits for motions to suppress and a motion for the Franks hearing. So these were the exhibits that Ann Taylor was going to present during the 2 days of hearings in late January. And the first day was largely behind closed doors, so we don't know really exactly what happened. But this is a list of exhibits that Ann Taylor and the defense team were going to present in those closed door hearings. And, it starts out with email communications between Detective Payne, FBI agent Bellavance, and Latah County Prosecutor's Office. It talks about emails with additional probable cause attachments from FBI agent Nick Balance. We've been through all of that, but one of the things that I found interesting, so you go down through the exhibits that Ann Taylor was going to present, and we come down to right about the middle of the page, interview with Dylan Mortensen on 11/17/22. Okay, what's that? 4 days after the crimes of 11/13/2022. Then another interview with Dylan Mortensen on 12/1/22. So that's approximately a half a month after that. There were actually 3 interviews that were done during the hearings. The parties, both of them, referred to an interview that was done right after the 911 call when the police went to 1122 King Road in Moscow, Idaho. Where's that? They talked about it. And the other thing that's kind of interesting is they have the States Exhibit S1 and States Exhibit S2, those 2 interviews with Dylan Mortensen. But you know who's missing?
Bethany Funke.
Bethany Funk's not on the list. What's happened to Bethany? What happened to Bethany? Way back, and this could affect the trial, way back in the spring of 2023, remember, they wanted to bring Bethany Funke in for the preliminary hearing to determine, whether they had cause to go forward with the case. And they were trying to get Bethany Funke to come in to testify. At that point, she was living in Arizona, and she obtained an attorney who fought, and he was fighting to keep her from having to go back to Idaho. And this is when Richard Battanti came out with that affidavit that said that she has exculpatory information. Well, you'd think that if she had exculpatory information, wouldn't you, that she would be on the list here? But right before the preliminary hearing, the state opted, instead of having the preliminary hearing, to take it to a grand jury, a secret, private grand jury, and secretly indict Brian Kohberger. So where is Bethany? Did she see things that are inconsistent with what Dylan Mortensen saw? I mean, in the probable cause affidavit, again, she's used to kind of help put the timeline together. But if you noticed, it was all Dylan when it came to what we're actually seeing. So that leads me to believe, did Bethany see something different? What did she see? Did she, she was on the first floor, Dylan was on the second floor. Did Bethany see something else? Did Bethany see 2 people? Did Bethany see somebody going out the front door while Dylan saw somebody going out the back door? Remember all those crazy thoughts about there was a naked man that ran out the door? I mean, whatever happened with all of that? I mean,
Well, my question is because it says like state exhibits 1, 2, 3, that means they're presumably just not going to use Bethany's interview at all then in this scenario, but they must have had some type of interview with her immediately after the murders happened. She wouldn't have just not spoken to the police, I'd imagine.
I would imagine that was absolutely done, but it's not on the defense team's. She's not on the defense team's listing of exhibits. Look at this. There's Cy Ray. There's more messaging with Brett Payne. There's a lab report of fibers, hair, no connection. All right, could that be Murphy the dog? Biology analysis notes, photos, negative blood. DNA, January 23rd of 2023. What? If the crime occurred on November 13th of 2022, that must be results of some tests. Idaho State Police Forensics. There's the 2 interviews with Dylan Mortensen. So I don't know. That just, to me, raises a lot of questions. Then she has some case law, a Department of Justice interim policy. What could that be? Could that be the FBI's agreement that they would not use genealogy sites, DNA that was provided by individuals who subscribed but did not want their DNA used? I mean, what could that have been? Here's an affidavit for the search warrant regarding AT&T, the first warrant. Well, that would have been one of these Exhibit A's that was done collaboratively that nobody will buy, nobody will take ownership of. So to me, that is troubling. This witness list gives us a little bit of a insight into what has been going on in the case and what Ann Taylor is trying to do. Here's these affidavits for search warrants for an order for the pen register and trap and trace device. Here's another one for the trap and trace device and non-disclosure order. So I just, I don't know. Pennsylvania State Police report, general offense report, which leads me to think about another troubling aspect of the case, which was, the probable cause affidavit itself in Idaho has never been released. The Pennsylvania probable cause affidavit was released, and then Exhibit A, which a lot of people, including me, erroneously call the probable cause affidavit, that 18-pager in Idaho, is actually Exhibit A. The Pennsylvania probable cause affidavit and the Pennsylvania Exhibit A signed by Brett Payne have been released in full. But the Idaho actual probable cause affidavit has never been released to the public. I've never seen it. It's not there. You can look on the docket. It's not there. Back, remember when I was all excited that the judge said, "Here's a procedure to see if you can get information from us in sealed documents." One of my requests was for the actual probable cause affidavit in Idaho. The court said, "Nuh-uh."
Yeah, that was like the one thing that you were primarily excited to get and ended up not getting. So that was a bummer.
Yeah, and it only took them 3 days. It only took them 3 days, which, for the court, unless you're Judge Cannoni in the Reed case, that's a long, that's light speed. That's that was fairly quick. So then that brings me to the question of the revelations during the hearings. What about all these? What about all this blood on the handrail inside the property? What about the glove outside that had human body liquids on it? How come we're going to the ends of the earth? How come we're going to the ends of the earth on this one speck of single source DNA that was on the sheath? What? That makes does that make any sense to you, Lainey Law, or am I exaggerating?
No, it doesn't. And the thing is if we're not caring about the glove or the blood on the handrail, then why does the knife sheath itself make such a difference? If the blood on the handrail or the glove on the handrail, like if those are things that don't matter in this case, then why would you pinpoint on this sheath? I guess is the question that I'm asking.
And I don't have an answer for that. I mean, I have the same question. I mean, it was a little teeny tiny little speck of blood that was on, I'm sorry, it was a teeny tiny little speck of DNA that was on the brass little attachment to the knife sheath, the brass snap on the knife sheath. And that's it. It was just a little teeny tiny little speck. It wasn't even enough to make a full DNA profile. They had to add to it to make a full DNA profile. So why did they go to those ends and then subsequently try to cover them up, which we can come back to? But there's blood on the handrail and there's this glove with body fluid outside, and not so much. I'll move along. There's nothing to see here. I mean, I heard one person say, well, they know who did that. They know. I have inside sources, and I know who did it, and they've dismissed them as suspects. What? Get out of here. Be serious. Let's be serious here. You have a little teeny tiny little speck of DNA on a brass tack, on a brass snap on a knife sheath. And that's where we go to the ends of the earth. And then the blood on the handrail and a glove outside. That's like, oh, that's nothing. Lenny, just ignore that. That's not. Come on. Let's be serious about this case. And the other thing is that, okay, fine. You say to me, they have the DNA on that knife sheath, and when they arrested Mr. Kohberger, they did a cheek swab, and those two match. That's it. And the judge himself, Judge Hippler, says, isn't that probable cause every day of the week and twice on Sunday? No. Let's employ a little bit of analysis and realize again that little teeny tiny little speck was so small that they had to augment it during the IgG process. And why did Attorney William Thompson, the chief prosecutor, who's now taken kind of a backseat, why did he go to the ends of the earth to try and protect that whole process by which they arrived at the full DNA profile? That makes no sense at all. Excuse me, Judge Hippler, but no, it does not make probable cause every day of the week, and especially not twice on Sundays. It just so, and then why did Judge, the predecessor judge in this case, say, all right, I'm not going to force, after Thompson fought, I'm not going to force them to disclose everything to the other side. Disclose it to me in camera. That means in private, in my chambers, so I can, look at it away from everybody else. And I'll take a look. And that's what he did. The prosecution reluctantly gave up the IgG analysis paperwork, and the judge took a look, and he did order that some, but not all of it, be disclosed. What are they hiding?
What doesn't make sense to me is that they had this conversation and they allowed some of it, but not all of it. So what was it that the state was? Are they trying, is the state still trying to hide this? Is the judge trying to hide it?
Yeah. I'm sorry to interrupt you, but that just angers me so much. What are they trying to hide about this process to get to the spec? People say, oh, well, they have his DNA on the knife sheath and they have his swab, case closed. No, the case is far from closed. Why doesn't Judge Hippler take a look at the ruling that Judge made, that we're not going to disclose that? I know more than you, defense. That's a conflict of interest right there in my mind. That's my opinion, that the judge had more information than the defense and refused to order the prosecution to turn that over. So I'm just thinking, way too much has been made of that. And why do they have to keep hiding that? If it's such an open and shut case, and if it's obvious, twice on Sunday even, why has that process been kept so simple? That's just one of the ongoing things that I think will be an issue in trial. How did you get to that? Why, if you're going to bring up the DNA match between the sheath and the cheek swab, well, how did you get the DNA on the sheath? Oh, you're not to disclose that? I move for mistrial. Or at least, mark the record for an appellate issue, because it's just, I don't know. It made little or no sense to me when that happened. And the other thing about the knife sheath, I've always had a problem with the knife sheath, because if Mr. Kohberger was such, and he's only a suspect, and we've said that all along. We've been accused of being pro-burgers. Is that what they call us? Pro-burgers and guilters. Are those the two? It's almost like this isn't a football game, folks. This isn't the Super Bowl where it's either team A or 2B. That's not what this is. We're talking about a man's life. We're talking about, sending somebody in front of Idaho's firing squad. And so it's very troubling, and it should be troubling, that we just assume that the knife sheath was left there by the suspect. I mean, that was a party house. It had been visited by the police on noise complaints 3 times in the months leading up to November 13th of 2022. There were people in and out of there all the time. Who's to say that one of the partiers, and there's some crazy video out there, you probably know what I'm talking about, Who's to say one of the partiers didn't leave it there? Who's to say one of the residents of the house didn't leave it there? But if there's this guy who's a criminology student who studied with some of the top professors in Pennsylvania and now in a graduate program in Washington, he planned this out so well and on such a small timeline. Who's to say that he didn't realize, oh, I left my sheath. I better go back and get it. I mean, I don't know. Just questions.
Well, I understand your point with that question, though, because it's like if everything else was done so perfect, is the knife sheath part of what you brought in really where it's all going to go wrong? I mean, obviously, we don't know. And I've said this before, those communities kind of have to hope that he's the one that's guilty. But it is strange, and we've talked about it before, where everything else went so perfectly that this tiny trace amount of DNA is all we have that was left on an entire knife sheath that was forgotten about is kind of crazy.
If you know enough how to, I'm not a weapons guy. So I can't be an expert with respect to this, but it's just common sense, folks. It's just, thinking about this realistically and thinking through and analyzing with a little bit of common sense. If someone knows enough about how to handle a military grade knife like that, wouldn't they know how to keep control of the sheath? I mean, a sheath is something that attaches to you. This is one thing I remember from Boy Scouts. A sheath is something that attaches to your belt and it doesn't go away. And I would think that if you're going to commit a crime and you're an expert and you're going for your PhD in criminology, you would know enough to, keep it on your belt and not, leave it behind. It's just, and how many people traipsed through that house from the time that these crimes were alleged to have happened until it was discovered? It just, I don't know, makes no sense. Makes zero sense to me. There was another document that I found in going through all of this that I think deserves our going through. Thank you. So this is a notice of intent to use evidence under the Idaho Rules of Evidence, Rule 404B. Comes now the state of Idaho by and through Ashley Hush Jennings, Latah County Senior Deputy Prosecutor, and hereby gives notice pursuant to Idaho Rule of Evidence 404B2. The state of Idaho intends to present evidence of crimes, wrongs, or other acts. And I'm thinking, wait a minute, Mr. Kohberger's committed other crimes? This raises relevancy issues in court. But wait, there's more. Video of a traffic stop. That's all it is? I thought,
my biggest crime.
They had him on something. I mean, way back when he was a teen, apparently he took his sister's iPhone, was it? I got corrected last time. He took something. I think it was a watch. Was it his watch? Anyhow, it doesn't make any difference.
Criminal behavior.
He took his sister's device and sold it. And apparently that was while he was having some issues. And he got over it. Anyhow, so I thought, get out the dun, dun, dun. There's some kind of a big crime. No, This is what Ashley wants to use. Video of a traffic stop occurring at West Pullman Road, Farm Road in Moscow, Idaho on August 21st of 2022 involving Brian Kohberger and Latah County Sheriff's Office Corporal Darren Duke. Citation number XYZ issued regarding the same traffic stop discovered as Bates stamp 13012.
You don't think that's on par with stealing and selling a watch, getting pulled over?
How many times, and I'm not gonna dox you because we've talked about your traffic record, but I know when I was a kid, I mean, I think I barely had my license probably 3 months when I got stopped for doing an LA roll through a stop sign in Pennsylvania, where I grew up. And the Pennsylvania police, at least way back then when I was a kid, they didn't take kindly to that. And I didn't see the police officer, and he pointed out to me that in Pennsylvania, we stop at stop signs. Unlike up here in Massachusetts, I learned we don't stop at stop signs.
We have no markings up here. We don't have stop signs, the lines.
There's a comedian, I can't remember his name. He says in Massachusetts, green means forget it, just go. Yellow means go faster so you can beat the red light. And the red light means it's still good for 4 or 5 more cars.
Yeah.
That's
Well,
just
that was my drive today. I was driving earlier and I was questioning if I should go through this yellow light. It was, questionable yellow. I go
Right.
through it. Of course, the person behind me is going through. I'm like, that light was definitely red. I didn't see it turn red, but there's no way it was still yellow.
But anyhow, so not to make light of this, and I know we're going to get nasty comments. This is not funny. You two are being too light. Whatever. Okay, fine. Comment. It helps us. It helps us with the algorithm, doesn't it? Whether they're nice or not. Anyhow, so what's this all about? The state intends to introduce this evidence for the purpose of proving defendant's identity, vehicle address, and phone number. This issue has been previously addressed by the court in the December 15th, 2023 sealed order denying motion to dismiss indictment on grounds of biased grand jury, inadmissible evidence, lack of sufficient evidence, and prosecutorial misconduct. See page 45. I'd love to see page 43, but it's all sealed. This makes me think, wait a minute, we've all been told that, there's this video out there of this car driving around on Linda Lane and it's going this way and going that way, but it's fuzzy. I've called it Fuzzy Wuzzy Was a Car because to those of you who know the video I'm talking about, that could be a Honda, that could be a Toyota, that could be a Chrysler, I forget the model. It's Fuzzy Wuzzy Was a Car. So this tells me that the state is grasping for straws to identify this car if they have to use the video of Mr. Kohberger in a traffic stop.
Look, he has a white car. Get him.
Because, the rules of evidence are very strict about, prior bad acts. And it's got to be, you can't just say, well, because Mr. Myers did an LA roll through a stop sign 90 years ago, now he's guilty of murder. No. There's got to be a nexus. It's got to show a pattern. It's got to show a habit. It's got to have some special theory of relevance. And this ain't it. So yeah, I just think that motion in itself, or a notice saying that they're going to use this at trial, I just think that shows that the state of Idaho is grasping for straws. Mm-hmm. And again, have you noticed how quiet William Thompson has been in all these hearings?
I know Ashley is completely taking over, it seems.
Yeah, she's taken over. She's no longer Ashley Hush Jennings. She's Ashley. I'm
in charge.
I'm the big person now.
Ashley Head Honcho Jennings.
So I don't know. There's just some of my thoughts about this whole matter, and we'll have more as time goes on because, in the couple of years since this has happened, we talk about this issue here and that issue there, and we talk about tunnels, and we talk about, tearing down the property, and we talk about, they not only tore down the property, they buried it in an undisclosed location, which I think I've heard that people know exactly where it was, but. So my point is, over the years, we've had little drips and drabs and crumbs, and it's time to really start nailing it all together, because the more we put together, the less it really fits together. Those are just my ramblings.
Yeah. And, I think a lot of people have similar thoughts with your ramblings. We grabbed some viewer comments for today's episode. So this is one of our previous videos on the case. And one of our commenters, Crash, says, "Thank you, Andrew. I said long ago that we had not seen the actual PCA, which was something that Andrew had once again brought up in that video. Being told, yes, we have, and then pointed to what I call attachments of Payne and Blaker. With that being said, is the public normally privy to that information?"
Yeah, I've seen it in a lot of cases. Yeah, a lot of times. And not only that, but like 911 calls, which that's another crumb in the case that, a lot of times, back when I was a reporter, you'd go to an arraignment and the cops would hand you police reports and they'd hand you a copy of the 911 call. No, it's yes, you do see information like that. Absolutely.
Perfect. And did you want to read this comment from Donna?
Our friend Donna Limbo. She is a regular. The viewer who left the negative comment should have provided specific examples to support their claim. As you mentioned, there are insiders following this case. it's possible one of them could be giving you this negative comment incognito. Running a YouTube channel takes a lot of hard work. Yes, it does, Donald Limbo. And this channel does a great job reviewing the cases. And you know why I really appreciate that is because both you and I and some of the other people that help us behind the scenes have regular day jobs. I'm still practicing law, and I have clients that are calling me right now. Why isn't this getting done? You've got this. I had a hearing this week in a federal case. So Godspeed to the creators that are out there every single day doing 4-hour segments. I can't do that because I've still got my head, in my files and my work and, putting together arguments and exhibits. And so thank you for recognizing that, Donald Lembo. We do the best we can, just part-time, as I think it was Attorney Bethany who said, and he'll probably call me and yell at me for saying this, but I think it was him. Remember, he said, we're only part-time grifters.
Exactly, yeah. Oh my God, I took that and I started saying that to my friends. That was the funniest thing in the universe. How dare we? Our criminal behavior of not dedicating 40 hours a week on this. It's basically, sometimes it feels like such a significant portion of the week. I don't even know how Andrew gets most of it done.
And Bethany, there's a guy who's at the top of his game. I mean, he practices law in Manhattan. He's got a busy case schedule. I've talked to him off record about how busy he is on some of his cases. We are too. And for him to say that, I just laughed. I should pull that clip out, rerun it, and then he'll definitely call me and never come on our show again.
So we have from Lane Cleardale. I think part of the privacy issue isn't what happens when you put your DNA or information into a system. It's the issue of, if I have a family member that does law enforcement have the right to use someone else's submission to link to me if I don't consent to anything, especially when it's coming from something like transfer DNA that can't really be tied to a specific time or place. And I think that is a very common concern that this is putting to the forefront of people's minds. I haven't done a DNA test, but I have a sibling that's done a DNA test. So when I am going around touching every single thing on campus and something happens on campus, am I going to be held accountable? There's no way of knowing.
Yeah, and I think this viewer points out, what has become an issue in this case, and that is people that go to these genealogy services, they just want to find out who their ancestors were. And there is a little checkoff box that I do not want this to be used by law enforcement, and they have an expectation that will be honored. The FBI has said that we will not use that DNA, but that has been violated in the Kohberger case. And that's an issue. I don't think it's really an issue for Mr. Kohberger, because the issue is whether his rights were violated. And I think Judge Hippler pointed that out very articulately. I know I might have made a comment before in this episode, but I think he was very articulate, saying that doesn't come back onto Mr. Kohberger. It is a valid issue. I'm not saying it's not a valid issue, because I've gotten some nasty comments on that. And give me more. Again, it helps with the algorithm. But anyhow, so yeah, it's an issue. And thank you.
All right. So next up,
Jackie Robinson. In regard to the IgG and privacy issues, I have done the 23andMe, and now I wish I wouldn't have. I don't want people, even law enforcement, using my personal information and DNA for any reason without my consent. And we just talked about that. Mm-hmm. But then there was another comment that we had, that somebody said that they had done one of the genetic genealogy sites, and they actually, because of their DNA, some relative got caught and charged with a crime. And so they were happy. So there's that.
Both
I'm not
sides
saying
of
either
the coin.
position is right. I'm just saying it's that.
Screw your uncle. Boyd says it was several weeks later when he was arrested. If he was going to destroy the evidence, he would have already done it. So I'm wondering if they collected some promising evidence during the raid. Likely not.
No, because I don't know if you remember earlier in this case, they disclosed lists, inventories of what they got. Now, whether those lists are accurate or not is a valid question, but we went over the inventories that were disclosed when they searched the property in Pennsylvania, Mr. Kohberger's apartment in Pullman, Washington, and his office. So there's that. They did list all the items. Some of the listing items were rather general, like a computer. I forget whether it was an Asus computer or whatever it was, but that's kind of general. But who knows? Okay, Boondog, if the police just showed up and tried to arrest him and a shootout would have happened, they would have claimed, why would you assume a guy accused of a quadruple homicide would go without incident? All right. Okay.
Fair analysis. I'm not even going to give that name an attempt. If true, to me, the biggest problem with Brian Kohberger's DNA is that it was microscopic in quantity. If you pick picograms, it's trace DNA, pretty much accepted, or at least argue that trace DNA is not reliable in terms of how it got where it was found, because our trace DNA is widespread by transfer. And that is our last comment that we have today. But I think that's a big concern that a lot of people have on the top of their minds, is that we don't have any proof as to what time, what day, or anything along those lines with the touch DNA.
Yeah, and we did an episode previously in which I cited 2 cases that were overturned, 2 convictions that were overturned, in part on touch DNA, and the court took a look at some expert documents and tomes on the subject of touch DNA, and the court said, touch DNA, if corroborated, will listen to the evidence, but without corroboration, which means some other evidence that supports it, we're not going to allow a conviction to be based on touch DNA alone. So on that note,
you guys, thank you so much for making it this far into the video. If you made it this far, comment your mood with an emoji today. Comment how you're feeling right now, whether you're having a bad day or a happy day. Just give us a little emoji smiley face, and we appreciate you guys so much for making it all the way to the end.
I didn't ask you for your closing comments. I don't know if you want to post where you've already told us a lot of your thoughts, but my closing thought is that we've only touched on some serious questions underlying this case. Please don't say we're an anti-Kohberger or pro-Kohberger. We're just saying that analytically, if you use your common sense and you read into these documents and read the information that's out there, there are some serious questions out there about this case.
Yeah, definitely, guys. I think it's always good to want things to be done properly, and it is crazy in these huge cases that people are watching from across the world, everything that happens, and just the locked doors, and we're just gonna have to see how it all turns out. Thank you, guys.
Okay, so don't take it from us, don't take it from anyone else, because everybody has their own viewpoint. Think, use your head, use some common sense, and guess what? Be nice.
Whether you are in the grocery store, the gas station, or anywhere else, please remember to be kind to people. You don't know what they're going through. And the same goes for our comment section. We want you to comment, but be nice, be kind, be positive if you can. And thank you for watching. Be sure to like and subscribe. Have a good one.